Thank you. Okay, well, we will go ahead and get started. Welcome, everybody. Thanks for joining this morning for our Water Resource District Secretary training. This is, I think, the third or fourth training that we've done, and really excited to have Sean Fredricks from Ohnstad Twichell with us today. He is going to present on subsurface drainage permitting, some of the processes that water boards go through. So he's going to do his presentation, and then we will have time at the end for questions. And I know we have this scheduled for about an hour. If we go a little over, that's just fine. Want to make sure that folks have a chance to get their questions answered. And we will be obviously recording this, and it'll be available on our website if you want to go back and listen to anything that Sean had to say. We'll also have his presentation available for everybody too. So with that, I will turn it over to Sean.
Hey, thanks, Danny. I know a lot of you folks. I work for some of you, and I do get some questions from folks with whom I do not work normally about tile frequently, and I'm happy to answer beyond just today. If anybody has questions about a particular tile application or about tile permitting in general, shoot me a note, give me a call. I'm happy to talk about it. Sometimes I'm trying to think of, I can't remember the specific number, but there have been years where I've processed over 100 tile permits. So I do this all the time. So if you have questions, feel free to ask them in the future. And as far as today, go ahead and interrupt me if you have a question about anything. You don't have to wait till the end or anything like that. So I'm going to share my screen here. Everybody seeing that?
Yep, that looks good.
I take it you're seeing it. Okay. All
Yep.
right. Thanks. All right. So I'm going to take you back to, I think it was 2005 when I processed my first tile permit. It wasn't specifically a tile permit at that time. For many years, we operated under the old surface permitting statute. That's what I have on the screen now. And I think, like I say, I think 2005 was when I saw the first application that proposed installation of tile. And so in those days, there was the administrative code that supported the statute, but we were operating under the surface permitting statute. And we didn't have anything specific to tile, and that wouldn't come until, I want to say 2011 was the first time we had some legislation specific to tile, if I remember right. And Representative Wes Belter, I think, if I remember correctly, I think Wes was the legislator who proposed tile permitting legislation. But prior to that, we sort of slogged through with the surface permitting statute. And that presented some issues. And I think it's important to recognize where we came from so that everybody can understand why we have tile permitting that's separate from the surface permitting piece. And it'll also help frame some of the debates we had about tile and all the various iterations of tile permitting statutes. And I think that's important. This is a training about, getting through the actual permits, the applications as they come in. But it's important, I think, and helpful to understand the background in terms of the debates that were ongoing at water resource district meetings and at the legislature and et cetera, so that you can understand why the statute says what it says now and why there are some actions you have to take and some actions you cannot take. And so that's why I thought it'd be helpful to go back to the beginning. And so in 2005, I think it was in Sargent County, I saw the first permit application that proposed installation of tile. And so, I touched base with the state at the time, and everybody was sort of trying to figure out how to deal with this, right? And the North Dakota Attorney General, after a few years of operating under this surface permitting statute, folks were landowners were frustrated, tile contractors were frustrated, water resource districts were frustrated, and we asked the state engineer at the time, hey, look, from your, and what I was telling people was, look, I have a statute, right? And I have to operate under that statute. Um, and I'll get to, in a second, I'll get to why that was kind of controversial, not kind of controversial, highly controversial. And so we asked the Attorney General, look, from your perspective, and the state engineer, from your perspective, does tile permitting fall under the surface permitting statute? And the answer was yes. Why was that a problem? Well, still today, this is the current surface permitting statute. And still today, if you get a surface application as a water resource district, that's a completely separate process. It first goes to DWR. They conduct their statewide interdistrict significance review. They forward the record of decision to the water resource district, et cetera, et cetera. The administrative code provides an outline of the steps you have to take to process a permit application for surface. Okay. Tile is separate, but back in those days, it was the same process. It'd go to the state first. Okay. And one of the things that we as water resource districts have to determine once we get an application, a surface permitting application, and in those days a tile from the state was, and this is right in the statute, first thing we have to determine is, will the project result in adverse impacts to downstream properties? Okay. And if so, you will attach an easement requirement, a downstream flowage easement requirement. Now you still have that requirement for surface permitting. And as a side note, I know that there are water resource districts out there who do not do that because you have to go through this 8-point analysis when you get a surface permitting application. If the review, and normally I like to have the water resource districts have their engineer review it and determine whether or not there are going to be adverse impacts as a result of the project. Okay. So if the answer is yes, then you have to require a downstream flowage easement as a condition to the permit. Now, when tile permitting wasn't all that popular at the time, nobody had really thought about this and how this would impact tile. But as we started to get these things, and I got a few of them where the project was going to discharge into a road ditch, for example, and we had to determine, okay, does that result in downstream impacts? And I'll tell you, we struggled with it for a long time. Chad Engels, a lot of you might know Chad. He sort of operates in the Minnesota sphere these days, Minnesota watershed districts. But Chad and I were working for the Sargent County Water Board, and as I note, that's where we got the first application, and we had actually a number of them down there before I saw them in any other county. But we sort of struggled through this, trying to figure out, okay, what exactly is a downstream impact when it comes to tile, right? And Chad researched it and found there's salinity issues initially, although that's a temporary issue, right? If you're a downstream landowner, though, in addition to that salinity might be a problem. Also, it's presenting new water, right? New drainage. Well, is it really or isn't it? Okay, it depends on where it was going to flow initially. But at the time, downstream parties were pretty upset when there was tile draining on them. And so the Water Resource District was getting it from both sides, right? The tile applicant was saying, it's just a little tile project. It's not going to hurt anybody. And the downstream party was telling the Water Resource District, hey, wait a minute. This is introducing new water. It's got salinity issues. If you approve this without requiring an easement, I'm going to sue you. Okay. And so we were hearing it from all directions. And so what ended up happening in some situations is we would conclude, okay, this does look like it's going to result in some downstream impacts. So as a result, under the statute, we had to require downstream flowage easements as a condition to the permit. So we'd approve the permit. We'd send out the notice. But the notice would include a condition that the applicant's project or permit is not effective until they obtain a flowage easement from the downstream landowner. Well, what ended up happening, and a lot of you folks probably know this happens in surface permitting too now, right? It became sort of a Hatfield-McCoy issue, and not really related to the drainage and the impacts of drainage. It was, like in all water issues, right? there are relationships and generations old debates amongst families. And like I say, the Hatfield-McCoy issues. And so the downstream landowners were refusing to grant flowage easements, and not necessarily because of impacts, but because, whatever somebody's great grandfather said to, the other, right? Some decades ago. So they couldn't get their easements. And so there were no projects. So that became a problem. And, we had all sorts of pretty contentious water board meetings. And again, the Water Resource District, Chad and I were struggling through this, trying to figure out, all right, how do we operate with a tile project or tile application when all we have is a surface application? So we operated under that for a number of years. And again, a lot of projects just didn't happen because the downstream party was refusing to grant the easements, the downstream flowage easements. So that sort of situation is how we operated for a number of years. 2011, like I say, I think was when we got the first tile permitting statute. And then just as a side note, I want to say we had a new statute every session until 2021. And that's the one I'm going to talk about. But initially, the question was always, before the legislature, was always, all right, what do we do about downstream parties? How do we protect them? Should we protect them? Does tile result in impacts? A lot of legislators felt like, well, look, this isn't much water. There aren't any impacts. And there were a few pretty contentious committee hearings, and water resource districts, they wanted to protect mostly their legal assessment drains, project that, discharge into legal assessment drains. They wanted to ensure that there wasn't going to be erosion as a result of a project. So they wanted the ability to attach some conditions. But again, we had that downstream landowner debate. And so initially, if I remember correctly, in 2011, Representative Belter's bill, I think what he said was water resource districts could require easements, but only up, only up to 1 mile downstream. After that, any impacts are minimal, right? And so we operated under that statute for at least a session, but we were still getting the same issue, right? We still had downstream landowners, even within 1 mile, refusing to grant those easements. And so projects weren't happening. They weren't going in. We were approving permits, but with downstream flowage easement conditions. And so projects were not being installed. The ones that were discharged directly into, that pumped right into a river or a pond or slough or lake, a lot of those were still happening, although still we had to consider impacts. And so, you get those situations where perhaps there's a slough that is on, that straddles 2 quarters. That's a situation that can still be highly contentious now. What do you do about that? Are there impacts from that? If you discharge into that slough, does it result in impacts? All right. And, obviously a lot of the downstream landowners were arguing, yeah, sure it does, because there's going to be more water. It's going to flood my acres, et cetera, et cetera. So we had the 1 mile downstream condition for a couple of years. That was proving to be problematic again, because downstream landowners were still refusing. At some point, I want to say 2017, there was a new change where, all right, this downstream flowage easement issue is a problem, right? It's killing projects, and everybody sort of acknowledged that. What do we do instead? There was, I can't remember which legislators were involved, but we ended up with a system where when we got an application, we had to provide a 30-day notice to downstream landowners, everybody within 1 mile. And we had to do it by certified mail. And you had to have the notice out for at least 30 days before you could approve the permit. And so then the downstream landowners could come in, but they had to present evidence, actual technical evidence that the project was going to result in impacts to them. And then you could require some consent from the downstream party. So that created quite a burden for water resource districts, because we'd get an application and we would have to, and as a side note, we were forced to determine downstream landowners ourselves. So we'd get an application in the boards I work for, I'd have to do a deed search. It wasn't just tax parcels, it was deed searches. And those can be, time consuming and pretty cumbersome. If there's a trust owns a quarter here, there's a remainder interest for a quarter, this quarter is owned by 4 people, but among those 4 people, somebody has a remainder. I mean, sometimes we had to send out downstream notices to, 12 different parties. And then they had 30 days to return, their comments, et cetera, et cetera. It was incredibly cumbersome. And again, it was based on deed searches, and we had to do certified mailings, and we couldn't approve until we got evidence that the certified mailing was signed for. And it was kind of ridiculous, right? So we sort of operated under that, I want to say, for 4 years. I think there was a tile bill in 2017. I don't think there was one in 19, if I remember correctly. And we still had to operate under that, I want to say, for 4 years. And it was difficult and cumbersome. And there were still downstream parties who complained, and, projects weren't going in at the rate that they probably should have been. And, so nobody was happy. Downstream parties weren't happy. The tile applicants weren't happy. Ag groups were not happy because tile wasn't happening as quickly as it easily could have. And so in water resource districts, frankly, weren't happy because there was so much footwork to do on the front end. So 2021, Cindy Schreiber-Beck, Cindy's passed away recently, and just as a side note, just a great person, incredibly pragmatic legislator. I really appreciated Cindy as a person and as a legislator, and she ended up drafting this bill, right? The statute that we operate under now. And Cindy, as you know, was from Richland County, works for Ellingson Drainage. So she, wanted to represent those interests, but also worked very closely with the Water Resource District down there. Monica Zentgraf was a longtime Secretary Treasurer in Richland County, and Cindy and Monica worked closely together. I worked with Cindy while she was drafting, discussing and debating all sorts of bills out there, right? Water bills. And Cindy ended up inviting Monica and me to get together and talk about, hey, look, what can we do about this tile permitting stuff, so that we can get a bill, get it approved. It's not going to make everybody happy, but let's try to find a middle ground. And I think Cindy did a really great job on this bill. Now, one of the things we can talk about, maybe as we move along here, is some folks weren't happy with the time frame. Some folks aren't happy that we didn't end up including that. I don't mean we, but Cindy didn't include, downstream consent as a condition, permissible condition, that kind of thing. In the end, was everybody completely happy? No. But, I think, as a result of that bill, we have a pretty workable tile permitting regime right now. And one thing that Cindy told us at the time, I should also mention Matt Lindsay from DWR was involved too in a lot of those discussions. And I'll go over the application form here shortly. And Matt provided the state's input on a lot of this stuff. And Matt's a great resource. And like I say, I'll go through the application form. He let us provide input on the application form. And so, like I say, I think to Cindy's credit again, she wanted to ensure that tile was going in, okay, so that ag folks, ag interests were happy enough that, hey, this is a pretty reasonable tile permitting situation. We didn't have downstream parties who could hold projects hostage. Water resource districts, I'll go through this in a second. We were happy because we didn't have to conduct deed searches anymore. We didn't have to do these certified mailings in advance, et cetera. Tile contractors were happy because they knew when there was a completed application. And so this is a statute we're operating under now. Again, a lot of you folks are obviously water resource district folks. I'm sure some of you have complaints, and you're going to say, well, the water resource district should have more authority to require consent from a downstream landowner or something like that. I hear that a lot. What I can tell you is what Cindy was hearing from legislators was, look, we're sick of hearing about tile, number one. Number two, if we get more arguments that you need, as water resource districts, they need the authority to require consent from a downstream landowner. That's going to kill projects. We're kind of tired of all of this. If that's the position of water resource districts, we're going to throw tile permitting out the window. Nobody needs a permit. That's it. And I think Cindy's point at that juncture was, look, that's not a responsible way to handle water management. She believed firmly that there should be some tile permitting, right? But she also believed that it should be reasonable, and so that it wouldn't inhibit ag growth. And so this is what we have. All right, just wanted to give a background on how we got here on the statute. So let me run through the statute and tell you what we're dealing with. So the footprint, the permitting trigger is 80 acres of physical tile. So in the old days, right, it was 80-acre watershed impacted. Okay, and that's hard to determine. And to be frank, it's pretty easy to meet. It's an easy threshold to meet. You might only be installing 10 acres of tile, but if you're draining an 80-acre watershed as a result of that 10 acres, you would need a permit. That became kind of a confusing mess for ag producers, tile contractors, et cetera. Nobody really knew when a permit was required unless you conducted a LiDAR study or something like that. Cindy felt that, look, ag producers, tile contractors, and others need to know, we need a definitive answer on when a permit is required. So the answer is, if it's an 80-acre physical system, it requires a permit, okay? It used to be that, this was kind of controversial. It used to be that if you had surface inlets, that's basically a surface that, under the old permitting statute, that basically triggered surface permitting and could trigger statewide interdistrict significance issues. And as some of you may know, any of you who have processed a statewide or interdistrict significance permit, that can be an arduous permitting process. And so Cindy wanted to take that out of the equation on tile. So this is it's still pretty controversial, I think. I hear about it from federal agencies and others who say that, look, if you're draining a slough, that should be a surface permitting consideration, not tile. But under the tile statute, surface inlets as a component to a tile project no longer triggers any surface permitting. So that was a decision that Cindy made and that the legislature agreed with. That's, like I say, I still hear about that from federal agencies. They contact me saying, why didn't you tell me this or that? And I tell them, look, the tile permitting statute says that doesn't trigger surface permitting. I couldn't give you notice. And, so like I say, I still hear about that. For purposes
we have a question.
Yeah. Yes.
Don, Cass County, what is 80 acres of tile? How far away from each side of the tile do you go to determine 80 acres?
Yeah. So Bill, it's a great question, Bill. I'm not going to answer it because I don't want to back myself into a corner if I get a complaint about tile, because that has come up, right? Because you might say, look, if I just have a line, running down the middle of my quarter, and then I do have a couple of, little tile, a couple extra tile lines, is that 80 acres or not? And I had a complaint like that almost went before a district court, and I won't tell you which side the water resource district was on. There was no definitive answer. So Bill brings up a great point, right? What the bill was trying to do, the statute was trying to do, is we were trying to get a definitive answer for what requires a permit. We don't necessarily have it. I agree with you on that. And I'd be interested if there are any tile contractors on here, you can chime in. But
I'm almost kind of surprised, because normally when they design a drain field and set the tile lines, they set them so many feet apart. And if there's only, like your example, there's only one tile line,
Right.
I would think the contractor could specify it's X number of feet on both sides of that one line of tile. And otherwise, if you have several lines and they're 40 feet apart, you could assume 40 feet on any single line in that system. And then
Yeah.
at least you'd have some mathematics to
And
figure out what's 40
I do
acres.
hear that. Yeah, I do hear that same explanation from contractors, Bill, quite a bit. And so,
Okay,
but it's a great question. We don't have a definitive answer to it.
right. And
And
I think we should work to get that added to the statute to settle it.
well, okay. So here's the first of probably many comments that we should fix the tile statute.
I
and,
know.
and what I'll tell you again is, if we go, I'll get to that at the end. I think, Bill, the problem with opening up the tile statute is, again, the message from many legislators was, don't bring this back. Cindy's passed away, unfortunately, for all sorts of reasons. But the message we got was, if this comes back, we're throwing it out. They're not going to be tile permitting anymore. And so,
okay, gotcha. All right.
So that's kind of the message that we got. And so I agree with you. There are some things that I would love to go in and fix and change, but I personally, I'm dubious about going back to seek any modifications, just because, because I worry. Yeah.
Yep.
And just as a side note, why, just to, people might ask, I think most of the folks on here probably agree, but some people might ask, well, why is it important that there is tile permitting at all? Okay, so if a project discharges into, let's say, a legal assessment drain, I think the Water Resource District wants to know, first of all, that there's tile discharging into their project. Number two, we want to be able to protect our drain with erosion protection, et cetera. Number three, we need to know it's there because, for a couple of reasons. One is, we needed to be able to determine benefits from a legal assessment drain. Number two is, if we're doing work on a legal assessment drain, we need to know that there's tile infrastructure so we can tell somebody, hey, look, we need to go in and improve our drain. Can you move your tile, blah, blah, blah. So that's one issue. A lot of folks have all sorts of reasons why tile permitting makes sense, just for the simple fact that it's there, right? That the Water Resource District knows it's there. I mean, that's helpful for all sorts of reasons, right? But so anyway, I think Bill makes a great point here. I think that's true. I don't think we do have a completely definitive answer as to what's 80 acres of physical tile. And it's a great point. The next one, this natural water course piece, it becomes important because the way you process a tile permit application differs based on where the tile discharge flows. So if a project discharges directly into the Cheyenne River, for example, the Water Resource District essentially loses jurisdiction over it the moment it enters a natural water course. The Cheyenne's easy, right? It's a navigable water, is determined by the state. That's easy. But what if it discharges into, there's a natural swale across the parcel and it discharges into that natural? Or what if it discharges into a pond or something like that? I'll go through a sample permit application to describe how a project, how you process one of these if it discharges into a natural. But this definition is pretty important because where your tile discharge ends up dictates what conditions you can attach to a permit. And the natural water course definition was confusing for a lot of folks for a lot of years. Now, this statute says if a natural water course is defined by this statute, and it's pretty broad. Natural water course is constituted if there's a sufficient natural flow, et cetera, to form and maintain a defined channel. That's pretty broad. And then there is an administrative code chapter that specifically addresses water course determinations. And look, in the end, in my opinion, this statute is pretty broad as to what constitutes a natural water course. And so, again, that's important because if it does enter into a water course, you no longer have to provide downstream notices. Okay. And you basically cannot require, you can't attach any conditions the moment it hits the natural. In addition to that, specifically under the tile statute, if it's a USGS blue line, it's considered a natural. And we got that question a lot from folks, from tile contractors in particular. Look, if this flows into a blue line, that's got to be a natural water course, right? And Cindy felt pretty adamant that there should be some definitive answer that she explained to us that, look, tile contractors are using these USGS maps. We need to be able to use those. And so that's why she included that in the statute. Okay, if natural water course under that definition in the statute, and also PS USGS blue line. Okay, and you'll see in the let's see, where is it now? Or was it in the statute? In any case, the administrative code calls out situations where, look, here's the definition of a water course. This is separate from the USGS blue line, by the way. And so, a lot of folks weren't happy that this piece was included, but Cindy explained why tile contractors need it. And so if it discharges into a USGS blue line, then you don't provide any downstream notices beyond that. Okay, so that was important. Okay, then let's get into the application form. And so first of all, by the way, the fee for a long time, I think, was $100, all right, to process a permit application. And at this point in 2021, Cindy agreed that was not sufficient. Although we were able to convince her to remove the deed search requirement, there's still some processing that's going to take place. And so Cindy raised it from $100 to $500. So anytime, if your water resource district doesn't have a policy for this, I've got a policy document that you could, ask me for it if you don't have one. What I've done is the water resource districts I work for have approved a resolution saying the statute allows us to require a $500 permit fee. We're putting that into place. Some boards want to do these themselves in-house. Some of them do a really nice job. Some of them just approve them, and that's it. And nobody really knows what that means. And so a lot of the boards I work for ask me to do this, and I'll go through the permitting process here briefly, and you'll see kind of the steps that I take to cover you as water resource districts. And the $500, does it cover you completely? Not always, right? And so your general fund, you might be spending some money out of your general fund. Is that fair? Isn't it fair? Should we go in and change it to 1,000? Again, we were hearing from legislators, they're not going to accept that. And so, in 5 years or 10 years, is 500 going to be enough? No, it's probably not enough now, right? Except to go back in and to open up the tile permitting debate over the fee is probably not going to be a great outcome for us. But anyway, so this part is important. What does a completed permit include? Oh, where's the 3 days here? I'll get to the 3 days here in a second, but it's obviously the permit form itself. And I'm going to show this to you. This is the form that Matt and his team put together. And you got to have a completed permit application, obviously. Also, you have to have evidence of ownership information for the project that they're tiling based on tax rolls. And we asked Cindy to include that so we wouldn't have to do deed searches for each one of these things. So based on the tax rolls, so the application should include the tax parcel data for the project they're tiling. That has to be included. And again, I'll get to this permit application form in a second. They want a detailed project design. Here's your project layout. Here's your footprint. Here's where all the outlets are located. Here's where your surface inlets are located, et cetera, et cetera. Obviously, your permit application should include that project plan. Now, this flow map is separate. You want your project permit map or your project design map, but you also want a separate downstream flow map. And we explained, well, that's important for a couple of reasons. One is we have to provide downstream notice for everybody within 1 mile downstream, unless there are some exceptions to that. But so we need a very detailed and accurate map of that. And we weren't getting them. We were sometimes they were hard to read. We couldn't really tell, all right, is this on the north side of the road in the road ditch, or is it in the south road ditch? And we were very adamant when we explained this to Cindy that, look, we need this to be accurate because we have to determine who the downstream parties are. And she understood that. So that became part of the completed application. Then also, in addition to that map, we need evidence, tax parcel data showing us evidence of the ownership for 1 mile downstream along that flow map, along that flow path, because we have to provide notice to those people. Okay. Again, based on the tax rules. However, again, this is where we get into that natural water course piece. If a project discharges into a legal drain, a natural water course, a slough, or a lake, you don't have to provide notice. Once the tile discharge hits a natural, basically, or a legal drain, you lose jurisdiction. You can require erosion protection, and then that's it. You lose jurisdiction. So maybe it flows in a road ditch for 1/4 mile and then flows into legal drain number 1. Okay, for that 1/4 mile, you have to provide notice. But then once it hits the legal drain, no more notice is required. Okay. Okay. This really upsets people. And so the application, you as a water resource district have 3 business days to determine if the application is complete. Does it include everything that we need? Okay, so here's the application form. Again, a lot of folks sometimes forget to include this. Where does it discharge? And that can make it difficult for all of us. So got to make sure that it's all completed. You want to make sure all the acreage, blah, blah, blah. Okay, now the second page of the application includes, here's what it takes to make it a full and complete application. And, landowners who submit these things, even though this is right in the application, they hardly ever submit all of the required info. And so it's easy to say, look, you didn't look at this page. You didn't submit any of this, and you didn't give us a flow map, et cetera. So there's a checklist right on the application. And so Matt and his team included that. Really grateful that they did, because, I get these things all the time, and I'll have to email an applicant and say, look, you didn't provide a flow map. I don't know where your discharge is going, and you didn't provide any tax roll data for the downstream people. It's right on your application. Please submit it. So that's really helpful that that's on there. But this piece was controversial because it says we only have 3 days to determine if it's complete, if it's a completed application. Okay, why 3 days? And how could I accept that? Well, I wasn't excited about it, but what Cindy explained was, look, what we were seeing in some counties is we'd submit an application and then we would never hear anything. And we'd email them, and they wouldn't tell us what was happening, and they didn't approve it. And then we'd find out 4 months later that they said it wasn't complete. And I understand what she was saying. So they needed some assurance that somebody somewhere was going to look at this and determine if it's a complete application. Okay, and so I proposed 10 business days. They didn't feel like that was, they needed these things turned around quicker. They felt it was reasonable that it be 3 business days for the water resource district folks to determine if a permit application is complete. That's what we ended up with. Okay. I don't love it, but here's what I'll tell you is that the tile contractors, almost universally that I work with, I was gone for a few days in December, and I had a few permit applications come in, and I didn't review them until I got back, right? I wasn't going to make that an emergency. And so I reviewed them when I got back, and there were a couple that were incomplete, and I was past the 3 days, but I emailed them and said, hey, we're missing this downstream flow map. I know we're past the 3 days. Would you mind submitting it? Every time they've been very reasonable, and they've submitted it. So it's not great, right? But I understand why they wanted it, why Cindy wanted it in there, because they didn't want water boards to just sit on these things for months and not tell them what the problem is. And so that's why they included it. In my experience, the tile contractors are incredibly reasonable. And I work with these folks a lot, and I tell them, hey, I needed X, Y, Z. Can you submit those? And they always do. It's never a problem. So, but you only have 3 days technically to determine if the permit application is complete. Okay, that becomes considerably important because you only have 30 days. I'll get to the conditions here in a second. You only have 30 days to approve a permit. Let's see, where's that? Where's the 30 days? Where am I? Here it is. So you have 30 days after that 3 days to approve a permit application with conditions. If you don't approve it within 30 days, then it's automatically approved without any conditions. Okay, so the 3 days becomes important because the 30 days commences after that 3 days. So basically you have 33 days to process a permit application. And this is important because what I'm hearing is water resource districts out there are doing a couple of things. Number one, I've heard some are denying permit applications. You can't legally deny a permit application. So if you're doing that, then really the statute says if you send out a notice saying, nope, we've denied it, well, that's not effective under the statute. You can't deny it. So it's going to become effective 30 days without any permit conditions. So it's in your interest as a water board to make sure you consider these things within 30 days and approve it with conditions. And if you don't, it's approved. Okay. And I'm hearing that other boards, we only meet quarterly. And so we received this 3 months ago, but we're just approving it today. Too late. You've missed it, right? 30 days. Okay. So the 3 days and the 30 days become important. Here's another piece. The actual project design map, the one that shows you where the actual tile lines are located, etc. That is a closed record. You cannot provide a copy of that to anybody who asks for it. Now, a closed record basically is an exempt record. It says the water board can decide by motion to make it an open record. In my mind, that is not a good idea for you. Do not do that. Just don't provide a copy of the project plan to anybody. And some water boards, when I'm processing these things, I'll put the downstream flow map up on the screen, but recognize that if you have folks at your water board meeting, you can't even put that map up on the screen for everybody to see, right? That's a violation, right, of open meetings requirements. Why are open records requirements? Why was that included? Cindy and ag groups felt like, look, we don't want you sharing our tile project plans with, NRCS or other entities. And so that's why that was included. And so when you get one of these project maps, make sure you don't share it with folks. Okay, so these are the conditions that you can include. Now I'm going to go through these in my own draft minutes here. You only can attach these conditions. You cannot attach anything more than what is in this statute. And I hear about water boards who have done that. We're going to require the applicant to get permission from the downstream landowner. You can't do that. Okay, so just recognize and I'll go through the conditions here in a second. There are some conditions that we argued quite a bit about when we were debating this to protect legal drains, to protect downstream roads, township roads, county roads, etc., to protect downstream parties. So I'll get into that here in a second, but you cannot require the applicant to obtain consent from a downstream landowner. What I do is I'll include a recommendation. So we'll go through the conditions here in a second, and I'll show you the recommendations. You might suggest that they get permission from the downstream party, but you can't require it. So we have a very finite list of conditions that you can attach. All right. This is a set of sample minutes. And I also have a sample notice of decision, and I have a sample affidavit of service. So as a side note, again, Cindy did not require us to send these things out by certified mail. That was great. Instead, we just do an affidavit. You have to include an affidavit to make sure you're providing notice to the applicant, to DWR, to downstream road authorities, and to anybody within 1 mile downstream, also to the rural water system. And I'll get to that in a second, because you can include a condition to protect their lines, or you have to. So
Sean, should we be seeing something other than Century Code right now?
Oh, yes. Yeah, why is that not happening? All right, let me stop sharing here, Danny. Let me share this and let me know if... Okay. Everybody seeing these minutes?
Yep.
Okay, sorry about that. All right, so these are draft minutes, and I'll show you the notice of decision and affidavit of service shortly. So what I do is I go through a very detailed description of what the project is, all right, and also I include the date it was filed, and I include that in the notice of decision and in the affidavit of service as well, so that it's everybody in the world can see, hey, look, they filed it on June 1st, and the board approved it on June 26th, right? So they're within the 30 days. So include that date. I include that in everything. Then I include, all right, a very detailed project description. It's 160 acres, the northwest quarter of 33 in Tillable Township. Describe in detail where the pump is located, where the outlet is located, and in detail what the downstream flow looks like, okay? Now, people might say, well, why don't you just send a copy of your map, the downstream flow map, instead of going into detail about, well, because again, let me show you, I'll stop sharing this. Let me show you a copy of a map that I get from folks, and a lot of you folks probably get something similar. Let's see here. Okay. Here's a sample downstream flow map that I get. How detailed is that, right? So if I send this out, is that going to tell the world exactly where this flow is going? Probably not, right? And so it's important to provide in detail what the downstream flow path is. And I can give you, just leave it to a lawyer, right? I'm already rambling on way too long, but it's important to go through this in a lot of detail, because I had a situation probably 2 months ago where there was a downstream landowner approached a water board. Danny, am I showing the minutes again?
Yep.
Is everybody seeing the minutes? Okay. A downstream landowner threatened to sue the water board because they said, well, your lawyer didn't send me a notice. And so the chairman called me, and I pulled up the map that was submitted with the application. And then I pulled up our minutes and our notice of decision that went into detail about what the project flow map looked like and where the downstream flow was going. And it was evident as a result of the map and the permit documents that the person who called to complain was a 1/4 mile downstream further than 1 mile. And so that was important, right? It was not clear in the map. It was clear, though, in the minutes and in the notice of decision as to why that person didn't get a downstream notice. He was not happy, but we gave him the statute and we gave him all the permit documents, and he realized, okay, I can't sue him, right? And I pointed out, you can still sue the applicant if you want, but you cannot sue us. And so this is important, right? So 5 years from now, when somebody claims you didn't do it right, you can demonstrate, look, all we can work with is what the applicant submits. Based on the submission, here's the downstream flow path that we have. And as a result of that, we could only attach X, Y, and Z conditions, and et cetera, et cetera. So it's really important to have a really detailed project description. It can save you from getting sued. It can save your project applicant, and it can save you from legislative scrutiny later. If you can demonstrate, no, somebody, we hear it all the time. Last session it happened. Downstream landowners were coming in and saying, water boards aren't doing it right. They're not sending their proper notices, et cetera, et cetera. Hey, give me the application you're talking about. I'll demonstrate that we absolutely did it right based on the statute. If you want to change the statute, that's one thing, but I can demonstrate in detail what we did and why we did it. So it's important to have a very detailed project description and flow path. Also, it's important to identify in the minutes and in the notice, here's who owns the land that's being tiled, and here's who owns the land within 1 mile downstream. And again, that indicates to everybody why certain people are getting notices and some people aren't, right? All right, let me run through the conditions that you can legally attach to a tile permit. It's these 11 conditions. This comes straight from the statute. If you're going to discharge into a legal drain, this came from Monica in the Richland County Water Resource District. Ended up being a great idea. If you're going to discharge into a legal drain, we don't want your pump directly on our berm. It'll damage the berm, et cetera. So you can have this condition that says it has to be set back 25 feet. And, if you have a pump, and then you can have a buried pipe that discharges into the drain, but we don't want your pump directly on our berm, right? That's going to cause erosion. It's going to, so that's one condition. This is a standard one that I include in all of them. Install and maintain erosion protection. So that doesn't, in the legal drain, in the natural water course, in the road ditch, whatever. And these other two are similar. This one is erosion protection into a road ditch. This one is erosion protection into the natural. So you can include one of these three in every single permit, and we do. Here's one, another standard condition. If you disturb the area that you're tiling, installing your system, maybe a road ditch, et cetera, you've got to reseed it and remedy any issues you cause. This is another one that's standard. No installation within 20 feet on either side of a rural water line. And that is always standard. And that's why we always provide notice to the rural water system. If the project includes a pump outlet, you can force them to turn it off during, quote, critical flood periods. That comes straight from the statute. If there are critical flood period, if it's a critical flood period downstream, you can force them to turn off their pump. Let's see. Again, that's similar. Here's another standard one. If you modify your system in the future, if you have a 160-acre system and you add 80 3 years from now, you've got to come back and either get a new permit or we amend this one, et cetera. We include that on every single one. Here's an interesting one. If as a result of your project, new acres are going to benefit from a legal drain, then you can include, and it's not, that property is not included in the assessment district, through the tile permitting process and without having to go through a reassessment, you can include that property within the assessment district. So this set of minutes right here, okay, this property is not in the assessment district for Corn County Drain Number 1. As a result of the tile system, though, the discharge is going to flow into Drain Number 1, and so it will now benefit. And so you can include that property as a condition to the permit. You can include that property in the assessment district for Drain Number 1. And you have to go through some detail in your minutes as to what percentage benefit. And this one, it was 50. Okay, we're going to include the Northwest Quarter of 33 in the Drain Number 1 assessment district at a 50% level. Okay, that's a condition that you can do. And you don't have to go through the full expensive reassessment process. This one is the one I was talking about where we're trying to protect downstream interests. Now, if a project discharges directly into a legal drain, into a natural water course, a pond, a lake, you cannot include this condition. But if they discharge into a road ditch, for example, and it flows 1 mile downstream, you can require the applicant to basically fix any erosion or silt buildup as a result of their tile system, but it has to be directly caused by their tile system. And so there's a process there to go through if this comes up, but you can include this, you can include this as a condition to your permit. And somebody would have, some downstream party, whether it be a road authority or a downstream landowner, they would have to come in and submit pretty convincing evidence that the tile project is the result or is causing the erosion, et cetera. But at least it's something, right? And this is where some folks get upset and say water boards should have the ability to require downstream notice or downstream consent. again, we'll never get back there, okay, because downstream parties were holding projects hostage. But since this was what we came up with, and this was pretty contentious, not contentious in terms of with Cindy, but all the various interests were all pretty interested in what this was going to end up saying. And so we said, look, we want the applicant to have to repair something if they cause a damage. And the response from Cindy was, okay, but they better submit pretty convincing evidence that their project, that the upstream project directly caused the damage. And so we agreed that, okay, that seems reasonable. So that's what we came up with. So those are the only 11 conditions that you can attach to a tile permit. And again, I hear all over the place, folks are attaching additional conditions. You can't do it. It's not effective. You could be sued, or they could appeal your decision. We could end up back in front of the legislature where legislators are saying, hey, water boards are out there attaching conditions they don't have a right to attach. That's a problem, okay? So make sure you're following your tile permitting statute. Now, I mentioned before that sometimes we'll include conditions, almost all the time, recommendations. Okay, so we can't require a landowner to go get permission from tillable township to discharge into their ditch, but we can recommend it. And we do that frequently. If a project is if tile discharge is going to end up into a township road ditch, we'll notify the township, because we can do that. And we'll recommend that the applicant go get permission from that township, but we can't require it. So again, what we'll say is, for applicants' protection and to ensure protection of their tile system, we recommend that they get, if there's a pipeline that goes on a neighbor's property, we recommend that you get an easement from that neighbor. We can't require it, but we recommend it. If you're going to discharge into a township road ditch, we recommend that you get permission from the township. We can't require it, that kind of thing. And then we throw in a sort of a catch-all recommendation. Hey, if your project requires some other permit, you better go get it. All right. We don't have any jurisdiction over NRCS issues, 404 permitting. We don't want that jurisdiction, and we don't have it. But we're just letting you know that just by virtue of the approval of this tile permit, that does not mean that you don't have to go get other permits. That's up to you. That's your business. And we're not going to tell you you do or don't. But we're just letting you know, if you need other permits, you better go get them. So that's what that's about. I realize we're bumping up against the end here. I just wanted to show you a copy of a notice of decision that we share. Let's see, here it is. And again, the notice of decision includes, again, the detailed project description, the ownership information, both for the tile project or tile property and downstream. Or if you don't need to provide downstream notice, we say it right in here. Hey, it's discharging into a natural water course, so no downstream notices are required. And then at our meeting on X date, we approved the permit application that was filed on June 1st. And here are the conditions that we attached. And also, here are the recommendations we included. We knew we couldn't require you to go get permission from the township or a pipeline easement from your neighbor, but we recommended it, okay? That's our notice of decision. And then I'll also share, I just want to show you our affidavit of service, just so you can see it. Where's the affidavit of service? There it is. And so here's an affidavit of service, includes the applicant, includes the downstream landowner neighbors. This is if, for example, the project discharges into a county highway road ditch or DOT. Here's the rural water system. We always notify the rural water system so that they're aware of the 20 feet on each side and they're aware of the tile project. So those are just a few examples. I had a bunch of different permit samples that I was going to show you. And of course I rambled on too long. I don't have time, but I do want to show you this will take me 20 seconds. So it's redacted. This is from a real permit recently processed, but this is just a copy of the documents that we sent out. Here's the notice of decision. Again, project description, the conditions. Here are recommendations, and we CC Courtney at the state, the water resource district, and then here's the township, and then the rural water system, and then any downstream landowners. Here's our affidavit of service. And then you have to fill out a separate permit form. You can't send the application. And again, you can't send the project map, but you can send the downstream flow map. Let me see here. Here's one that includes the downstream flow map, just for the world to see. So I rambled on enough. We're already out of time, but does anybody have any questions about any of this?
Sean, there was a question in the chat, just wondering if the sample minutes that you presented, if those can be shared.
Yes. Thanks, Danny. I will share all of those sample documents with anybody who wants to see any of them. If you want some samples, and I'll send you in Word, I will send you the samples that have all the conditions. Now, again, you cannot, I've done this before where I've sent these out, the sample minutes and notice of decision, and then I find out that the Water Resource District is including them on all the permits, every condition. And so I just want to make sure that everybody understands. I will send these out. I'll send them to Danny and she can give them to whoever, or you can email me. But just make sure you only attach the ones that are applicable to a particular project. So there should never be a tile permit that has 11 conditions. Okay, so I just want to make sure everybody understands that. But yeah, I'm happy to share any of these documents with anybody.
Okay, Sean, I have a question on file retention. How long do we need to keep the drain tile permits?
Yeah, so there is no, the state has, this is sort of an open record question, but yeah, it's a great question. The state has recommendations for data retention or for document retention at the state. There is nothing in the statutes for us indicating how long we're supposed to hold it. So does that mean we have to hold it forever? Well, sort of. And so, in our office, we've gone digital, right? So we have everything we can save digitally. And, in the end, what's the answer? If I tell you 6 years, that's technically not correct because the statute doesn't say you can purge your documents after 6 years. And so I'm not going to sit here and say you're supposed to hold them forever, but that's kind of what the statute sort of suggests.
Okay, but if I upload them to digital, then the hard copies I could do at my discretion.
Yes, exactly. Yeah. Yes, Lori. Yeah, and I've done the same thing. I've gotten rid of all sorts of the physical docs. Yeah. Okay. Yeah. No, that's a good question. It's a good question. Document retention is a sticky issue for public entities because, the answer is basically, well, according to the statutes, we're not supposed to destroy anything. So, it creates an issue for you. But as far as the physical files, we're getting rid of them. We're purging them in our office too. We're going to just hold on to everything digitally.
Perfect. Thank you.
Yeah. Any other questions, folks? All right. If you have a question about a specific tile permit application, give me a buzz, shoot me an email. I'm not going to charge you. I'm happy to talk through those with you because I really want you folks to do these properly because for selfish reasons, I don't want us to end up in front of the legislature again, right? And I don't want legislators to say water resource districts aren't doing this correctly. And so if you have a question about an application, what am I supposed to do with this? Feel free to shoot me a note or give me a call. I'm happy to talk to you. And again, I'm not going to bill you for that.
Great. Well, thank you, Sean. As someone who works closely with the legislature, I appreciate that as well. I think we're at a good place right now, and it'd be great to keep it that way and not go backwards on things. So want to thank you all for attending this morning. Thanks again to Sean for the great information. As he mentioned, we'll get everything sent out to you, so you guys have that as a resource. And the recording will also be posted on our website, so you can go back at any point and listen to that if there's things that you missed or things you want to go back and listen to again. So with that, thanks so much for joining. And we do have the next webinar scheduled. Maybe if Julie has it handy, she could pull it up and let us know exactly what that is. but we do have the state auditor's office going to be on talking a little bit about audit requirements for water resource districts. We've gotten some questions about that, kind of what the requirements are and the resources that the state auditor has available for small political subdivisions like water resource districts. Julie, do you have the date for that offhand?
Yep, it is April 20th. Sorry, April 20th at 10 a.m.
Great, thanks, Julie. So when we send the recording out and all of the resources from Sean, we will include that date and time so you can get it on your calendars for the next training. And with that, thanks for your time, and we will see you next month.
Thanks, Danny. Thanks, folks. Have a good one.
Yeah, thank you. Bye.